During the 1940s, the United States entered World War II. Pressure from the involvement in the war compelled the United States government to introduce the Bracero program to supplement the shortage of workers in the fields and factories. Millions of Latino immigrants came to the United States. Cities such as San Antonio, Chicago, Detroit, and Los Angeles soon had growing Latin American communities. Accompanying the influx of immigrants came anti-Latino sentiment, and segregation was not uncommon. Many Latinos were barred entry into many establishments. Latinos were often treated as second-class citizens and were stereotyped as stupid, dirty, and undeserving. Gonzalo Mendez, his wife Felicitas Mendez, and their 3 children, Sylvia, Gonzalo Jr., and Jeronimo, moved from Santa Ana, California, to a farm in nearby Westminster City in Orange County, California, after they had leased the farm from a Japanese family, who was being sent to an internment camp in 1943. Gonzalo and Felicitas Mendez wanted both of their children to attend the 17th Street School, a school that was only a block away from their house. When the Mendez family brought their 3 children, Jeronimo, Gonzalo Jr., and Sylvia, to the school in order to enroll them, the administration rejected the 3 children and sent them to the city's designated Mexican school, known as Hoover Elementary. The school lacked a proper building, and the playground was surrounded by an electric fence, put up by farmers to keep their cattle from wandering. In an account by Sylvia Mendez, she recalls, "I remember a girl touched that fence. The shock did not kill her, but she did not get up until adults came to help her." In addition to the substandard buildings, the school's teachers would enact physical punishments for speaking Spanish, even as Spanish was a prevailing language the students spoke.
A young girl, I was 8 years old and didn't even know what was going on. I just remember going to the school and all of a sudden being told that I was not be able to enter that school. And my Aunt Sally that had taken us, took us home and told my dad what had happened, how we were not going to be admitted into that Westminster school at the time. And he thought that there had been a mistake, so he goes and speaks to the principal, and that's when he finds out that Mexicans aren't being allowed to go into public school. And so my father got really upset, and he decides to call. And he was talking to a friend of his, and he says, "Gonzalo, I just heard about this lawyer that fought the case. It was in Riverside, where Latinos weren't allowed to go into public parks." And he won it, and came out in the Los Angeles Times, and that's how he heard about the lawyer. He said, "I just heard about this lawyer, Gonzalo. He's in Los Angeles." And he was telling my dad, and my mother says, "Well, let's go hire him. We have the money."
Gonzalo Mendez eventually joined 4 other plaintiffs to begin pursuing legal action against 4 different school districts. William Guzman, Frank Palomino, Thomas Estrada, Lorenzo Ramirez, and Gonzalo Mendez would overall represent 5,000 students in their lawsuit. In 1946, the case of Mendez v. Westminster was heard by Federal District Judge Paul McCormick.
Throughout the trial, they're referred to as mentally inferior, dirty, lice-ridden, and it's just heartbreaking. And there was an expert that testified that there were teachers that wouldn't even hug. They would hug their white students, but they would never think of hugging their Mexican students for fear of getting lice on themselves. And so you can imagine what it must have been like for a child to see that they are not loved by their teacher. And I think that's one of the most powerful things teachers can do, is to really be able to demonstrate that. And so I can't even imagine, but and at that particular time, there was such a division, such a clear division, and it was okay. And it was allowed and it was acceptable at that time.
Federal District Judge Paul McCormick delivered a historic ruling in favor of the plaintiffs. He ruled that the segregation of Mexican Americans was unenforceable under California law, and that segregation violated the 14th Amendment of the Constitution. A paramount requisite in the American system of public education is social equality, Judge McCormick stated, it must be open to all children by unified school association, regardless of lineage. Directly after the ruling was delivered by Judge McCormick, the school districts appealed the case to the Ninth Circuit Courts. When the case progressed to the Ninth Circuit Court, the NAACP, or the National Association for the Advancement of Colored People, took notice of the ruling delivered by Judge McCormick. They saw it as an opportune moment to attempt to challenge segregation within the school system. Robert Carter, a lawyer for the NAACP, helped write an amicus curiae, or Friends of the Court legal brief, presenting substantial evidence that separate schools for ethnic groups were unequal. In addition, several civil rights organizations also contributed amicus curiae briefs. These organizations include the American Jewish Congress, the American Civil Liberties Union, the National Lawyers Guild, the Japanese American Citizens League, and even the Attorney General of California. On April 14, 1947, federal appeals court judges unanimously upheld Judge McCormick's verdict, stating that by enforcing the segregation of school children of Mexican descent against their will, and contrary to the laws of California, the respondents have violated federal law by denying them equal protection of the laws. The verdict handed down by the Ninth Circuit Court was the first successful school integration case in the nation. Consequently, the decision left the possibility open for the California state legislature to pass a law regarding the segregation of Mexican American students. Earl Warren, then the governor of California, signed the law that outlawed school segregation of any kind throughout the state. 8 years later, Earl Warren served as the Chief Justice of the Supreme Court and was part of the unanimous decision that overturned the doctrine of separate but equal in Brown v. Board of Education.
And I was 10 years old when we finally won the case, and I went to that white school, and this little boy comes up and says, "Ooh, you don't belong here. What are you doing here? Mexicans don't belong in this school. You're not supposed to be here. Who said you could come to this school?" He just went on, and I started crying. I didn't know what he was saying. I didn't realize what he was talking about. Because all this time being in court, all this time I had been protected by my parents. They had never really explained what was going on. They just, protected me, and we were doing all this. They were doing all this fighting, all this meetings and trying to. But I was not involved in that. So we finally won the case, and they took me to white school. And this young boy comes to me and he says those things. I start crying and I go, "Oh, Mom, I'm not going to go to that school. They don't want me in that school. I don't want to go to that school." She says, "Sylvia, don't you know what we were fighting for?" "Yes, so we could go to that beautiful white school with the monkey bars. You wanted us to have a playground just like the other one and go to that beautiful school." "No, Sylvia, that's not what we were fighting. Well, we were fighting because under God, we all are equal and we should all deserve the same equal education. And yes, you're going to go back to school." And yes, I went back to school.
Today, there are 2 schools named after Felicitas and Gonzalo Mendez in Southern California. More than 13,000 students attend each school. Out of those 13,000, 98% of students are Latino, and 92% qualify for reduced lunch. According to recent studies, though high school graduation rates have risen to 83%, only 18% of Mexican American students earn an associate's degree, in comparison to 52% of Anglo-Americans, and only 12% of Mexican Americans complete a 4-year college degree. Even though cases such as Mendez v. Westminster have broken down legal segregation, de facto segregation, which occurs when widespread individual preferences, sometimes backed up with private pressure, lead to separation. Therefore, regardless of who we are, it is essential to continue our fight for equal rights.